All right, so going from part one to part two, we're going to start out still in the MPEP 700. We're going to start out with utility. So utility, there's two places where you'll see it mostly. That's going to be 2107 and 706. So anything you're trying to patent, as you can imagine, it must have some type of utility. So that can be either asserted by an applicant, determined by the USPTO as utility from a person of ordinary skill. But if a lack of utility is found, then the burden of proof shifts to the applicant to show what that utility would be. So kind of going from there, we're going to start talking about further the examination process. So it begins with the first action. And so that can be meaning a couple different things. A first action on the merits is something related to a rejection or objection of the claims, versus a first action not on the merits would be a restriction requirement. So the response, it's going to stop the time period set forward by the office within a first action. So response by the applicant is going to toll that time period set forth by the office. As a matter of right, after a first action, you can have an interview, you can amend the application, you can submit an affidavit, and there's no 2-month rule, which we'll talk about in a little bit. But basically, those are kind of the main ones to remember what can be done as a matter of right after the first action. So then after the first action, if the next one may be a final rejection. So in some cases, it's not always a final rejection, but if there's any repeated action in the original application, then it can be made final. So if they made some sort of rejection about 102 and that was not addressed in any way by the applicant via an amendment or anything, they can repeat the rejection, and then that rejection will be made final. This action can also be made final by the action of the applicant, right? So if they're not addressing everything, if they're not bringing forward new evidence, then the examiner can say, well, we're going to go ahead and make this rejection final in that case. However, a continuation and substitute can have their first action be made final if they're repeating in any way. So if especially the substitute one is the hardest part about this, because if you'll remember, a substitute happens after an application is abandoned, and so it is basically the same application, but it doesn't get the benefit of the date. But an examiner can still make the first rejection final just by saying, hey, you still have these issues, you haven't fixed them, this is now a final rejection. So now once a final rejection has been made, that's going to set the clock for the remaining life of an application at 6 months, unless these things happen. If a notice of appeal is filed, that tolls the time period and starts a clock for an appeal brief. If it is put into a condition for allowance, so maybe a reply was made immediately to talk about the rejection, take it down in any way, overcome it in any way. And so in that case, the examiner could could withdraw their final rejection and submit a notice of allowability. You can file a continuation or an RCE. So the RCE does not count as a response, but as it does continue the prosecution. So now interviews will usually be granted after a final rejection, but there's no right to them. And also an extension of time is not required to obtain an interview. So kind of two good things to remember there, which could be areas to be tripped up on. You can only appeal after a second or final rejection. So that's another thing. And you can also only file an RCE after a second or final rejection. And that is something that is definitely an area ripe for questions, because it would be very tempting to, even after the first rejection, feeling like the examiner is not listening in any way and just wanting to file an appeal. But no, you have to wait until there's a second rejection before making that move. So now talking about amendments. So replies can be filed, but amendments are not always entered and could put the application in jeopardy of abandonment. So maybe if it's after a final rejection, the applicant feels like they put forward a very clear reply, but those replies are not always entered by the examiner if they don't feel like it would put the application in better condition for allowance or for appeal. And so in those cases, an advisory action would be issued, but at times that advisory action is issued after the statutory period, resulting in the application being abandoned. So then the question is, which amendments would be entered as a matter of right? So amendments which cancel claims, amendments which comply with formal requirements or the examiner requests, anything which is going to place the claims in better form for appeal. So those are the ones which will be entered as a matter of right. So remembering kind of those basic ones will be helpful in the future as far as answering questions where an amendment is made and you're trying to determine if that would be entered and if the examiner is just improperly ignoring them. So now transitional practice and the RCE. So the RCE is the newest one and that's currently tested. So transitional practice only applies to applications which were filed before 6/8/95, had an effective filing date of 93 or earlier, and are eligible for first submission after the final rejection to be entered as a right. So that's about all that needs to be said on transitional practice. Basically, whatever they reply after their final rejection, it's immediately entered, and there's no way that it wouldn't be entered or considered. So then the RCE, that is used for utility only, and that was used to replace the CPA. However, the CPA still remains for design. So if you'll remember, that is the continued prosecution application, and so it's just continuing prosecution beyond, in lieu of filing a continuation or anything like that. So for a national stage filing, they are required to be complete in order to file an RCE. So they must include the oath, translation, fee, anything like that. There are no divisionals allowed. So for an RCE must be about the exact same claims that the invention was about. So even if there was a restriction requirement and they're trying to switch the invention, no, it has to be the same claims. That once RCE is filed, this cuts off the patent term extension program. So any adjustment that might occur, it stops once the RCE is filed. A certificate of mailing, certificate of transmission, or the electronic filing system can be used to file an RCE. So then the question is, what has to be included within that? And that rule is 1.114, which I would definitely recommend memorizing because I think it's a very helpful rule to have off the top of your head. So you must include a request for examination, easy, a submission, and that submission could be an amendment that was filed already. So maybe it was an amendment that wasn't entered, but it was already filed, a reply to an outstanding action, or an IDS. So a lot of these depend on when they were found. So if an item that would need to be submitted with an IDS, so some patent or application that they wanted to be considered by the examiner, that, if you'll remember those rules, if it's late enough in the prosecution, then it would need to be filed with an RCE rather than just an IDS with an RCE rather than just within the application. So then there also is a fee, and so the fee cannot be late. If the fee is not included, then it is automatically considered abandoned. So now there's the 2-month rule that we kind of mentioned before. This is a good one to memorize. Pretty easy if you've gone through a couple questions of it, but basically 2 things have to happen. So first off, if a final rejection is issued setting a shortened 3-month statutory time period for reply, and the reply is filed within 2 months, and the advisory action, right? That's the advisory action is going to occur after a reply by the applicant in a final rejection, kind of saying, okay, here's where your application stands right now. So if that is filed after the 3-month period, any further deadlines in the case are set from the date the advisory action is mailed, but will not go beyond the 6 months from the original rejection mailing date. So kind of a lot to go over there, but let's see if I have an example. So basically that is, let's say, so basically just looking at example questions for that is going to be best. So if something was filed January 1st, if a final rejection is filed January 1st, the reply is set February, or is sent February 1st, right? So then it's filed February 1st. So they sent it within the 2-month period, but the advisory action is not set until April 3rd or something like that, right? So it's outside that 3-month statutory period set by the final rejection. So in that case, further deadlines are going to be set from that April 3rd date up until July 1st, right? So July 1st would be 6 months from the original date. And so before that, the next deadlines would be May 3rd, June 3rd, but July 3rd does not become the new deadline. It does not go beyond the 6 months from the final rejection mailing date. So apologize if that's very confusing, but definitely look at some of those old exams, try to think through exactly what that could mean. And then, of course, reading the MPEP is always helpful because they have some good examples in there. So now there is something you can do in examination called the petition to make special. So before August 25th, 2006, these were kind of the rules. So the free submissions included age, which is over 65, which is still free, illness, which is still free, environment, which is still free through the accelerated examination hoops, energy, same thing as environment, counterterrorism, also same. Then in this time period, also the things that had fees but were still special were prospective manufacturers. So everything was in place for manufacture. They just needed to go ahead. Infringement. So if their application was actively getting infringed, getting it published as soon as possible so that they could act upon those infringers. Safer DNA was considered something that with just a small fee could be made special because there was a lot of work that was done in DNA back then. And of course still now, but now it's not as necessary to have it be made special because there's so much working with DNA now. Then a request with conditions. So there's the conditions, you can look those in the MPEP, but it was things like completing a search, those sort of things. Anything to do with HIV, AIDS, or cancer treatments. Superconductivity. So it's a little bit sketchy as far as what the case is still with superconductivity, but basically from what I can find, it's still free with the accelerated examination hoops. So now let's talk about, and then biocheck by a small entity. So again, that's not the case anymore. So now let's talk about petition to make special after August 26, 2006. And so this is still in effect today. So accelerated examination, there are a lot of conditions to this, a lot of things that have to be done by the applicant, but the fee, it's more manageable than what we'll see in a moment for prioritized examination. But so for accelerated examination, there's a lot of conditions related to the search, how the application has to be, what kind of form the application has to be in, requirements for the applicant. I would recommend either memorizing MPEP 708.02a, remembering where to look that up, or reading that section until you feel like you're familiar with it. The applications which are not eligible for accelerated exam is going to be plant, a reissue, applications from national stage, re-examination procedures, RCEs unless they were previously granted special status. So an RCE can't be filed and then also filed the petition under accelerated examination. The health or age or PPH, none of those are eligible for accelerated exam. And so this one is completed within 12 months or until the following: the notice of allowance, final office action, an RCE, abandonment. And so kind of the only other rule that would be good to definitely memorize here that I wanted to highlight was the accelerated examination cannot have more than 3 independent claims or 20 dependent. And so if there is an amendment which brings it over that will also cause termination of the accelerated examination. So then for petitions to make special, these are only for applications filed after 9/16/11. This is called prioritized examination, also known as track 1. So this has a huge fee, but a lot less conditions than an accelerated exam. It has a special status until an extension of time is filed, amendments for claims exceeding 4 independent, 30 dependent. So remember the other one was 3 and 20. This one's 4 and 30. Any RCE is filed. A notice of appeal is filed. Suspension of action, notice of allowance, a final office action, abandoned, or the examination is complete. So as far as eligible applications for this one, that's going to be non-provisional, plant, RCE, but the request has to be made before the first action is issued, right? So going back to it's saying special status until the RCE, you can still get it within the RCE, but the request has to be made again. And the special status for the previous application is maintained until that's filed. Eligible applications also are those which have entered the national stage. So then this one, again, it has a huge fee. attached to it. So the specific listing of fees, because there's a lot of them, is further defined in 708.02b. And their chapter headings are very helpful for this section. If there are errors in the application which are not resolved the same day, so there's a filing fee missing, in any way the application is incomplete and not resolved that same day of filing, then any prioritized examination is dismissed, which is pretty harsh, but just a good method of completing examination quickly. Now, design applications, you'll notice they weren't on any of those lists of eligible or non-eligible. Design applications, you actually can get you can get it under accelerated examination. That is allowed. There are special petitions specific to design applications for expediting design applications. That is based on searches, a fee, a short description of references, and that is all found in 1504.30. And so a couple nuances to that one, which might be good to look at there. So one thing you might have heard mentioned once or twice is a suspension of action. So a suspension of action, there's a general one. That's a general 6-month suspension of action. And that can take place after replying to any outstanding actions, a petition for suspension, and a fee. The other suspension of actions can occur in a continued prosecution application, and that is not more than 3 months. That one would need to include a request at the time of filing, a fee. Then you have the RCE, also not more than 3 months. You have a request at the time of filing and a fee. And then you have the deferral of examination. And so this is not more than 3 years from filing date. And this has to be said very upfront. So this request is only granted if it's a utility, a plant, or PCT. There's no non-publication request, right? Those are filed initially, and there's no request for that. The condition for publication, it's in condition for publication, but there haven't been any office actions or notice of allowances. So if any of those have occurred, then immediately the suspension of or the deferral of examination is denied. And this is found in MPEP 709. Oh, and it also needs to include publication and processing fee. So now extensions of time. This section can be very confusing because of all of the different rules, it seems like, and definitely a lot of areas that actually do have to be memorized. So starting out with the rule for it. So 1.136a covers automatic extensions. And so automatic extensions are, in certain cases, up to 5 months. It is not available for official actions. All of those are going to be 6 months statutory. Under a statute. The primary examples which are eligible for automatic extensions are notice of appeal, notice of missing parts. It is not available when the main ones to remember, statutory, so if it's an office action, a reply brief, oral hearing, responding to a decision of the board, any sort of interference, any sort of examination, so during examination, I think that's supposed to say re-examination. Re-examination. I apologize. So under re-examination, for cause extensions can be filed if they're filed before the due date, but they're not automatic extensions. So then going into that, extensions for cause, that's only when the automatic extensions have been used up. So maybe there would be a case where you could go beyond those 5 months, and then after that there's extensions for cause saying, hey, I really need more time to get this information together, the draftsman for this drawing is taking longer than expected, etc. So then those which cannot be extended even for cause, these ones should be memorized. It's going to be the IDS, so any of those deadlines, issue fee deadlines, statute due date. So any of those cannot, and so I apologize, that's supposed to say statute. So any statutory due dates cannot be extended even for cause. The 3-month deadline for fee refund. So let's say you qualify for status as a small entity, but you accidentally paid the large entity fee. Then in that case, there is a 3-month deadline for the fee to be refunded, but that is a statutory period and that cannot be extended. So if you realize 3 months in one day that you paid however many hundreds of dollars extra, too late. filing the formal drawings at the time the issue fee is paid. So in some cases, there may be a notice of allowability. So that's saying that the application is almost in condition, just these formal things have to happen in order for it to be allowed. And so that can also a lot of times set a 3-month period for the issue fee to be paid. That cannot be extended. So then bona fide attempts at replies can be extended automatically. And that's all based off of the examiner. If the examiner feels like it's a bona fide attempt, then in that case they can help extend, but they have to be the one to offer the further time periods. But basically, you should never be under the assumption that you're getting an extension in any way. The method for obtaining the extensions of time, you can obtain them in pieces, which is kind of nice. So you can get 1 month, and then maybe you realize that you do need 2 months, and then you can just pay the difference and just keep adding on in that way. Kind of easy. You don't have to know how much of an extension you're going to need right up front. The petitions can be granted in the cases of general authorization for extensions, the payment of extension fee without specific request, general authorization for any fee. So I think a good takeaway here is if you in any way authorize the PTO to extend the application, give them access to a deposit account, they will work with you and do whatever they can to keep an application from going abandoned due to an extension of time. The due dates are calculated by the mailing date from the PTO. The MPEP 1834, that's going to cover lost or irregularities in mail. A very interesting section to read. I would definitely recommend reading it. Hopefully it won't come up too much because it is a little bit confusing, but there are certain provisions under there that if something happened in the mail where a substantial amount of time is lost due to some error in the mailing service, then the applicant or the practitioner, as long as it's within a certain period, then they can notify the PTO and let them know, hey, we don't have enough time with when this was received to make these changes or whatever needs to happen. And so they can petition or kind of request that due date to be reset, or you can get back, I believe, a substantial amount, equal substantial amount of time. So maybe if you lost 5 weeks, you can get 2 months back or something like that. I definitely recommend reading that section. It can be very interesting, or at least knowing where it's at, just in case a question like that comes up. So whatever the office sets, that is also what the due date. So for ex parte quail, that's usually 2 months. For restriction requirements, also 2 months. For notice of appeal, almost all appeal dates is usually 2 months. Reexamination, almost always 2 months. But then for office actions, a good amount of time, they're 3 months. So whatever the office sets, though, that is what the due date is calculated by. And it's based off the mailing date of the item, not whatever date it was received by the practitioner or inventor. Remembering the automatic, those can be obtained retroactively. Those for cause cannot be obtained retroactively. Further kind of miscellaneous date things. The deadline for providing a correspondence address is 2 months from filing. So that's different than some of those errors from filing. If you're sent a notice of missing parts, you have 2 months from the mailing date of that notice, seen here. But for providing a correspondence address, it has to be 2 months from filing. The extension fee is eligible for small and micro entity discounts. The PTO will do whatever possible to help avoid abandonment, so they'll change it to 2 months if they know that you need 2 months. And if you've already replied outside what the 1 month extension would be, then they'll just give you 2 month extension because it's needed. Filing response to a final rejection in a reexamination will automatically extend the deadline by 1 month. Deadlines on appeal are 2 months. Then when it comes to abandonment and revival. So abandonment can happen if there is an express abandonment or a failure to reply or pay an issue fee. Express abandonment is only the abandonment of the application, not the invention. So kind of what we talked about before. 102C covers the abandonment of an invention. If it's under the PTO fault, so maybe they didn't receive something, there was some irregularity in how the reply was received or something like that, then there could be a petition for withdrawal of holding of abandonment, and there's no fee needed for that. For revival, however, there has to be a petition for withdrawal of abandonment plus a response to whatever the outstanding action was, plus a fee. The other option could be a petition, filing of continuation, or a fee. And the petition would state that delay was unintentional. There used to be provisions within the law for unintentional or unavoidable, but they took that away. Now it's just unintentional. The terminal disclaimer can be used and included, but that is only for design applications. So terminal disclaimer is not required for utility or plant after 95. So a reconsideration of the decision for revival. So maybe there was a petition for revival and it got denied. Then in that case, within 2 months, there has to be a petition for reconsideration of the decision. As far as provisional applications, those can be revived, but they still expire at 12 months. Interviews, kind of just another aspect of examinations. That's why it's included in the MPEP 700. So an interview before filing is never granted. Interview before first action is only granted when it's a continuing application, substitute application. After a first action, it is a matter of right. So that's kind of a helpful little one to remember. We talked about that before, but just to reiterate here, after a final rejection, it's at the discretion of the examiner, but it's usually granted, which is nice. After an appeal brief, it is not normally granted. So we'll talk about that in a couple of videos, but after an appeal brief comes an examiner's answer, and then you file a reply brief, and then you have a chance for an oral hearing before the board, or the board will just hear the case. There doesn't have to be an oral hearing, but basically you're going to get your chance to talk and to make petitions and replies. And so they're not necessarily going to just go for an interview when you've already had chances to do that. As far as how to interview, so it doesn't change the need to reply to an office action. So that's an important one. So even if you are, it might be after the first action, you have an interview, the interview goes great, you still have to reply to the office action. You can't just let that go unanswered because of an interview does not count as a reply. The practitioner must record the information. So this is reiterated a lot within the MPEP, and I think it's just to kind of take that off of the examiner, and that the examiner doesn't need to write down everything that's said in an interview. That needs to be on the practitioner, as it's their application. The attorney also needs to set forth what will be done at the interview, so they can't just go into the interview just to kind of figure out where the examiner is at with different things. They have to begin the interview or set forth expectations of what arguments will be discussed, what maybe patents or publications will be discussed, that sort of thing. Interviews are not granted to any representative lacking power of attorney, any suspended or unregistered agent, unless they have a part of the application. So unless they are an applicant or have any sort of vested interest or are an inventor, those are the only ways they would be allowed to be at the interview. Anyone who's lacking the power of attorney and a copy of application. So that's kind of something that could be an area for questions. If an applicant shows up, or if just a person shows up and they have a copy of application and say that they are in a representative capacity, typically they will go ahead and have the interview. Maybe something happened where the attorney and the inventor couldn't come. So basically, if you have a copy of this application, especially if it hasn't been published, then it's clear that you do have some sort of authority. These interviews can be held without obtaining an extension of time. So that's kind of nice in cases of just needing to figure out, okay, do we need to invest in an extension of time, or is there no hope for this application? For reexamination, this I think is a very helpful area to kind of read, and this is in 2200, I believe 2258. So it's mostly the same in terms of who it's granted to, who must record information, doesn't change the need to reply, etc. But the owner or practitioner, they have to file a written statement of reasons for the favorable action. So a little bit of a confusing term, but I think basically they're just saying there just has to be a reason why things discussed at the interview should result in favorable actions. And it has to be within 1 month or with a response to the action. So whichever one of those is later, maybe you have some more time extension that can be done, but basically that's the gist of that part. And a third party is not invited to this interview. So if a reexamination is initiated by a third party, that could definitely be an area for questions to try to trip up. But the third party does not get to come to the interview. So now amendments in pending applications. And so the rule for this is CFR 1.121. So I did bold this because I think it's a very, very helpful rule to look at and read and maybe memorize that this rule exists. So changes in the specification, those are indicated by a marked up copy submitted in addition to the claim. However, new paragraphs or deleted paragraphs, those don't require a marked up addition. And so we kind of talked about that before, where something might be denied or considered an incomplete reply if there's not a marked up copy in addition to a clean copy. A marked up copy for a drawing is not required. That is optional. So there's preliminary amendment. Those are before a first action. Those are filed with a CPA filing if a preliminary is to be filed. So if you're filing a continued prosecution in a design, then you need to file it at the same day. Otherwise, it won't be accepted usually. It may be refused entry if it's interfering with an office action or if it's not filed within 3 months of filing date. So if a preliminary amendment sets forth new claims which are supported by the disclosure, but it's claims that would require more search, then they might be refused entry because the examiner might be, well, I'm too far into the search for this one. I'm not going to add in this new search until after this office action is issued. So, but they would notify of a refused action. Supplemental replies, so those are replies which happen after an initial response to an office action. Those are considered a matter of right if they cancel claims, they adopt the examiner's suggestion and therefore putting the application into condition for allowance. There is a reply to the office requirement after the first reply. So like it's any sort of formality or something that wasn't initially added in the first reply. If it's to correct the informalities or simplify issues on appeal. So then applications, and so kind of continuing this, again, rule 1.121. Remembering the oaths, those cannot be amended. So there's going to be no amendment, but you may be submitting a supplemental oath or declaration. An amendment after final that may or may not be entered. And it just depends on kind of what it does, right? If it's canceling claims, most likely it will be entered. If it's complying with some requirement with the examiner, most likely will be entered. Changing claim wording, that can be canceling claims where the new claims start with the next number in the application, amending the claims by submitting marked up copy. That's another way to do it. If words are added, then they are underlined in the marked up copy. If words are deleted, then there's a strike through or a double bracket used for up to 5 characters. So if you're trying to delete that can be kind of hard to see with a strike through, and so you would use double brackets. For amendments after a notice of allowance, not usually typical, but this has to happen before the issue fee is paid if it's needed for the disclosure and if no undue work is done by the examiner. So those are kind of the conditions where it would be allowed. The 4 whys must be included within the remarks added to these amendments. So that is why this amendment is needed, why no new search is required, right? Why you're submitting these amendments now, why would we not need to search further? Why the amended or new claims are patentable, why it was not previously presented. Once the issue fee has been paid, the only option is the withdrawal from issue. So that's the only reason that you would be able to get an amendment after the notice of allowance or submit any sort of information. So CFR 1.313 is what covers the withdrawal from issue. All right. Ooh, that was a lot, but hopefully helpful here. All right, thank you.